Today could be the last chance for Derek Chauvin to take the stand in his own defense. His lawyer is expected to rest his case if Chauvin testifies. That could open him up to harsh questions from the prosecution, and the stakes are high. He could spend up to 40 years in prison if convicted on the most serious charge against him. CBS News legal contributor and former federal prosecutor Keir Dougall joins us now to talk about what we can expect today. Keir, good to see you, my friend. So what are the odds that Derek Chauvin takes the stand today? Would you put him up there given the questions the prosecutor will ask?
So the odds are generally very low. They're generally low in any criminal case that a defendant would take the stand. The decision is ultimately up to the defendant, him or herself. That's one of those decisions where you get advice from the lawyer, but it's not up to the lawyer. My advice to Mr. Chauvin at this point would be not to testify. The defense expert witnesses, I think, have created a pretty serious question for this jury. They've got opposing experts testifying on the key issues. And remember what the burden of proof is here. It's proof beyond a reasonable doubt. So for the prosecution to obtain a conviction, every single one of those jurors will have to conclude that the prosecution's experts are correct beyond a reasonable doubt, and the defense experts are incorrect, effectively, at a very high level of certainty. And so I think the defense has got a lot to work with after the testimony that we've seen. I would advise him not to testify.
So our Jamie Yuccas was one of the few pool reporters that was allowed in the courtroom yesterday, and she said that she saw Derek Chauvin taking an awful lot of notes. We've seen him doing that throughout the trial. I just wonder, because I've seen other defendants do that as well, you know, why would he be taking notes? Is this something that attorneys tell their clients to do, or is he sort of really assisting in his defense?
So that's a great question, and you know, I think that it's a much better look, frankly, for a defendant than to be simply sitting there, perhaps looking bored, perhaps looking disengaged. You know, Mr. Floyd's justice for Mr. Floyd is on the line. Mr. Chauvin's the rest of his life is on the line. So looking attentive, just as a perceptual look, I think is better than, you know, not looking attentive, and taking notes can help do that. There's also help that a defendant can provide to counsel. The whole point of that relationship is to allow the exchange of information that, you know, may help arm a defense lawyer with a point or an inconsistency in the testimony so that it can be brought out at the trial.
Keir, the jury has been very interested in some of these defense witnesses, according to Jamie and some of the pool reporters. We note that Jamie reported that many of the jurors took notes during Dr. Fowler's testimony, especially when he said that the exhaust from the nearby police cruiser may have contributed to Floyd's death. They also took a lot of notes during the use of force expert testimony the day before, but according to Jamie and the other reporters who comprise the pool, that's been the case pretty much throughout the entirety of the trial. What does that tell you about how the jury is thinking about this case, but specifically as it relates to the defense?
Right. So the jurors have a tough job ahead of them. They've, as I just mentioned, they've now got a dueling sets of expert testimony, and they understand that when they go back to deliberate, of course, they're going to have the fate of Mr. Chauvin in their hands. It doesn't surprise me that they're taking this seriously, that they're wanting to take notes to remember. And it also doesn't surprise me, for instance, I think you just mentioned that they were taking notes with some of the defense expert testimony. We've heard, I think, a new issue relating to carbon monoxide. So none of that surprises me, and I think it means that these jurors are taking their job seriously, because it is going to become serious for them when they deliberate.
So the judge ruled that the prosecution will be allowed to present rebuttal witnesses once the defense rests. They've already presented a number of witnesses, more than the defense. Who would they need to put on the stand?
Rebuttal is typically used to respond to a new issue that's raised by the defense. For instance, one of the new issues I think that's come up on defense is this issue about carbon monoxide. So to the extent the prosecution wants to talk about that, they would be allowed to bring in new witnesses to discuss that new issue. Rebuttal is typically only used for new issues brought out on defense. It's not a vehicle for the prosecutor to redo its initial case in chief.
So, Keir, Dr. Fowler testified yesterday that Floyd's drug use could have contributed to his death because drugs like methamphetamine can narrow the arteries to the heart. I want to play a little bit of that exchange where the prosecutor pressed Dr. Fowler about Floyd's drug use. Watch.
Typically, doctor, when somebody passes away from a fentanyl or opioid overdose, one of the hallmarks of that is that they are very sleepy, and they will tend to be unarousable and pass away in essentially a coma, right?
Correct. If they are passing away from fentanyl overdose, that's what happens.
And Mr. Floyd was manifesting none of those outward symptoms, was he, on the ground?
Correct. It does not exclude the fact that it was still having a depressive effect on his respiratory system.
So the prosecutor was trying to poke holes in Dr. Fowler's theory there. Do you think that this line of questioning was effective?
Yeah, so this is where the battle is going to be fought throughout closing arguments, perhaps on rebuttal, and this is where the jurors are going to have to really do their work. So Dr. Fowler, his overall takeaway was that the cause of death is indeterminate or undetermined. He said he would fall back to that because of all these different potential causes. That's an element that the prosecutors, they must prevail on this. They must prove that the death of Mr. Floyd was caused by Mr. Chauvin, not by one of these other potential causes. And so this line of cross-examination by the prosecutor was effective. But again, you're asking a jury to resolve a disputed issue between dueling sets of experts, and their job is going to be difficult.
All right, Keir, thank you so much.
Thank you, guys.